So from time to time, people need to challenge a power of attorney or a guardianship. We see this relatively frequently in practice, particularly the challenges to the powers of attorney. Power of attorney can be challenged based on whether the person giving the power had capacity to give it when it was signed. If there's evidence that somebody was legally incapable of managing their own affairs, then they can't, while suffering that incapacity, give the authority to somebody else to manage their affairs. And the same occurs with guardianships. You can have arguments of undue influence. That again, you can have powers of attorney where there was an existing long-standing power of attorney, and then the person enters a new romantic relationship, or one of their children is devoting more time and attention, and the individual wants to change the power of attorney, or the power of attorney gets changed. And it really does, I mean, again, the person has the agency. They can make the decision to change the power of attorney, provided they have the capacity to make that decision. And the way you challenge it is based on lack of capacity and undue hardship, primarily, with a bit of another criteria being mismanagement of what they've been granted powers for. With respect to a guardianship, there's a number of narrow areas that can be challenged on things like whether the guardian is capable of taking care of children, whether the guardian has the financial ability. There can be instances where something has happened to the guardian after they were appointed, but before that takes into effect. Criminal convictions of certain areas would automatically disqualify somebody from being a guardian, but that is something that would certainly require you to get legal counsel to guide you through that process.